If you're a gun owner wondering why everyone's talking about Bloody November, it's because something catastrophic just happened at the Supreme Court. And what they did in November 2025 is about to make you a felon in 2026. Here's what's terrifying. Just weeks ago, the Supreme Court quietly rejected 70 Second Amendment cases in a single month. And starting January 1st, 2026, just days from now, those rejections will turn law-abiding gun owners into criminals. New restrictions go into effect. New arrests will begin. And if you don't know what changed, you could be next. In the next 18 minutes, I'm breaking down exactly what got destroyed in Bloody November, the two cases that could save us, and most importantly, what you need to do right now before 2026 hits. Let's get into it. Alright, let me paint you a picture of what just went down. Starting back in June of this year, the Supreme Court began what I can only describe as a systematic destruction of Second Amendment cases. We're not talking about a few rejections here and there. We're talking about dozens of critical gun rights cases that could have protected you and me, shot down one after another. But November 2025 was the bloodbath. That's why gun rights groups are now calling it Bloody November. In a single Supreme Court conference on November 21st, just over a month ago, the justices had 59 Second Amendment petitions sitting on their desk. 59 cases, all waiting for review, all challenging unconstitutional gun laws. Want to know how many they took? Want to know how many they said, yes, we'll protect your gun rights on this one? 2. They accepted exactly 2 cases. The rest, either denied outright or left hanging in limbo. And here's what nobody's telling you. Those rejections don't just affect abstract legal principles. They affect you. Starting January 1st, 2026, less than 2 weeks from now, the consequences of Bloody November go into full effect. Now, before we dive deeper, you need to understand how this works. When the Supreme Court denies a case, when they say we're not going to hear this, they're not necessarily saying the lower court got it right. They're just saying, we're not touching this right now. But here's the problem. When they refuse to hear a case, the lower court's ruling stands. It becomes the law in that circuit, in that region. And in almost all of these 70 cases we're talking about, the lower courts ruled against gun owners. They upheld bans. They upheld restrictions. They upheld laws that strip your Second Amendment rights. So by refusing to step in, the Supreme Court is effectively letting those bad rulings become reality. Starting in 2026, millions of gun owners across multiple states will be living under restrictions that wouldn't exist if the Supreme Court had just done their job. Think about that for a second. The one court that's supposed to be the final word on constitutional rights just looked at 70 cases and said, meh, maybe later. Meanwhile, you could become a felon for doing something that was perfectly legal a year ago. And here's where it gets even more frustrating. The Supreme Court typically hears between 1.5 to 2.5% of all cases that petition them. That's normal. They're a small court, they can't hear everything. But here's what's not normal. After the massive Bruen decision in 2022, you remember that one, right? The case that was supposed to expand gun rights and protect constitutional carry? After Bruen, lower courts have issued over 2,000 decisions on gun law challenges. 2,000 cases dealing with how Bruen should be applied. And the Supreme Court has been largely silent. They're letting different circuit courts across the country come to completely opposite conclusions about the same constitutional questions. One circuit says magazine bans are unconstitutional. Another circuit says they're fine. One circuit protects your right to carry in certain places. Another circuit says those same places are sensitive zones where you can be arrested. And the Supreme Court? They're just watching. They're letting this chaos develop. Now, some legal experts will tell you this is normal Supreme Court behavior. And technically, they're not wrong. But here's what's different. We're talking about a fundamental constitutional right. The Second Amendment isn't a suggestion. It's not a privilege granted by the government. It's a right that the government is supposed to protect. And when different parts of the country are interpreting that right in completely opposite ways, when you can legally carry in one state but become a felon for the exact same behavior in the next state, the Supreme Court should step in and clarify. But in Bloody November, they chose not to. So let's break down exactly what they rejected and what it means for you starting January 1st. Let's start with the big ones. The cases that should have been easy wins for gun rights. Case 1, Snope versus Bruen, the AR-15 case. This case challenged Maryland's so-called assault weapons ban. We're talking about AR-15 style rifles, the most popular rifle in America, owned by millions of law-abiding citizens. Maryland banned these firearms outright, and the Fourth Circuit Court of Appeals upheld the ban. Their reasoning? Get this. They said AR-15s are military-style weapons that don't deserve Second Amendment protection. Pause right there. Military style? The AR-15 is a semi-automatic rifle. One trigger pull equals 1 round fired. That's it. It's not full auto. It's not a machine gun. It's not a military weapon. But the Fourth Circuit didn't care about facts. The Supreme Court denied this case back in June. But here's the one silver lining. Justice Kavanaugh wrote separately to suggest the court will tackle the AR-15 question in the next term or two. Now, that sounds promising, right? Next term or 2 foot means maybe 2026 or 2027. But here's my question. Why not now? Why let millions of gun owners in Maryland and potentially other states remain disarmed for another year or two? 3 justices, Thomas, Alito, and Gorsuch, actually voted to hear this case immediately. They dissented from the denial. That tells you something important. There are justices who want to protect your gun rights, but they need 5 votes to grant a case. They only had 3. So where were Roberts, Kavanaugh, and Barrett on this? That's the question that should concern every gun owner going into 2026. Case 2, Ocean State Tactical versus Rhode Island, the magazine ban. This one challenged Rhode Island's ban on magazines holding more than 10 rounds. The First Circuit upheld the ban using what they call historical grounds. Their argument was basically this. Well, they didn't have high-capacity magazines back in 1791 when the Second Amendment was written, so you don't need them now. Let that sink in for a moment. By that logic, the First Amendment doesn't apply to the internet because the founders didn't have Twitter. The Fourth Amendment doesn't protect your cell phone because they didn't have smartphones in 1791. You see how absurd this reasoning is? But the Supreme Court denied this case too. The same 3 conservatives, Thomas, Alito, and Gorsuch, wanted to hear it. The rest, not interested. And here's what this means starting in 2026. If you live in Rhode Island or any other state with magazine capacity bans, you're now stuck with that 10-round limit. Period. The Supreme Court just let it stand. And other states are watching. If the court won't strike down Rhode Island's ban, what's stopping California, New York, New Jersey, and every other blue state from implementing the same restriction? Nothing. Absolutely nothing. And that's exactly what they're planning to do in 2026. Case 3, the felon possession cases, 8 rejections at once. Now this is where Bloody November really earned its name. The court rejected 8 separate cases, all at the same time, challenging federal law section 922G1. This is the law that says if you're a convicted felon, you lose your gun rights. Forever. For life. Now, before you say, good, felons shouldn't have guns, hear me out on this. These weren't cases from violent criminals. These were cases from people convicted of nonviolent felonies. We're talking about white-collar crimes, paperwork violations, tax issues, things that didn't involve hurting anyone or even threatening violence. Some of these petitioners made a mistake 20, 30 years ago. They served their time. They paid their debt to society. They've been law-abiding citizens ever since. And now they're asking, can I get my Second Amendment rights back? The Supreme Court's answer in November? No. And we're not even going to discuss it. 8 different petitioners, 8 different fact patterns, 8 different legal arguments. Some were facial challenges, arguing the entire law is unconstitutional. Others were as-applied challenges, saying, look, maybe the law is okay in general, but in my specific situation, as a nonviolent offender who's been clean for decades, this is unconstitutional as applied to me. Denied. All of them. Every single one. The message was crystal clear. The Supreme Court is not interested in debating whether lifetime gun bans for nonviolent offenses are constitutional. And starting in 2026, that means hundreds of thousands of Americans who thought they might get their rights restored, they're out of luck. Case 4. Vla versus United States, the gun manufacturing case. This case asked a simple question. Does the Second Amendment include the right to manufacture firearms without government permission? Right now, if you want to make guns or deal in firearms commercially, you need an FFL, a federal firearms license. You become a licensed dealer, which means you're subject to federal regulations, inspections, oversight. Your Fourth Amendment rights basically go out the window because the government can inspect your business at any time. The petitioner in this case argued that the Second Amendment should protect your right to make and sell guns without having to get government permission first. The Ninth Circuit rejected this using what they call the ancillary rights doctrine. That's fancy legal speak for, sure, you have the right to own a gun, but you don't have the right to make one without permission. The Supreme Court denied this case without even a comment. And here's what that means going into 2026. If you're thinking about starting a gun business, building firearms, or dealing commercially, even in a small way, you better have that FFL. Because the Supreme Court just signaled they're not going to protect you if you don't. Case 5. Missouri's Second Amendment Preservation Act. Missouri tried to fight back. They passed a state law attempting to nullify certain federal gun regulations within Missouri's borders. The law even said they'd fine federal officers $50,000 for enforcing certain gun laws in the state. Bold move, right? States' rights, fighting federal overreach. Lower courts struck it down, saying it violated the Supremacy Clause, the part of the Constitution that says federal law trumps state law when there's a conflict. The Supreme Court let that ruling stand. No review, no comment. Missouri's attempt to protect gun rights? Dead on arrival. And the message to other states thinking about doing the same thing in 2026? Don't bother. The Supreme Court won't back you up. Alright, now we get to November 21st, 2025, just over a month ago. This was the day that will go down in Second Amendment history as the moment the Supreme Court had every opportunity to protect gun rights and chose to punt. On this single day, the Supreme Court had 59 Second Amendment petitions on their conference docket. Let me say that again, 59 cases, all dealing with fundamental gun rights, all challenging unconstitutional restrictions, all waiting for the justices to decide. Will we hear this? Will we protect the Second Amendment? 3 cases were denied outright that day. Denial 1, a challenge to Section 922(g)(5)(a), the law that prohibits firearm possession by people who are unlawfully present in the United States. Now, you might think, well, illegal immigrants shouldn't have guns anyway. But the petitioner's argument was actually interesting from a constitutional standpoint. They said there's no historical precedent under Bruen for this kind of categorical ban. Whether you agree with that argument or not, it's a legitimate constitutional question. The Supreme Court said, nope, not interested. Denial 2, Jenkins versus United States, yet another felon possession case. But this one asked the broader question, does categorical disarmament of all convicted felons, regardless of the nature of their crime or how long ago it occurred, survive constitutional scrutiny? Again, denied. Denial 3, another felon case, this one with a motion for expedited review. Basically the petitioner saying, this is urgent, please hear this quickly. The court's response, not only will we not hear it, we won't even hear it fast. Denied. But here's what's really important. What about those other 56 cases from November 21st? They weren't denied. They were relisted. That means they're in limbo. Suspended animation. The justices are still supposedly thinking about them. They might grant some in the future. They might deny them all eventually. Nobody knows. And this is where legal strategy gets complicated. Why would the court keep 56 cases alive while denying others? I've got a few theories. Theory 1, they're waiting for the right vehicle. The Supreme Court is strategic. They don't just take any case. They want clean facts, clear legal questions, and a good record that lets them make a broad ruling without complications. Some of these 56 cases might have procedural problems or weird facts that make them less than ideal test cases. So maybe the court is waiting for that perfect case that lets them say what they want to say without legal complications. Theory 2, they're waiting to see how their 2 accepted cases turn out. The court did accept 2 gun cases this term. We'll talk about those in a minute. Those 2 cases might answer some of the questions raised in these other 56 cases. If that happens, some of these 56 might become unnecessary to hear. Theory 3, they're stalling. This is the cynical view, but hear me out. Maybe some justices don't want to expand gun rights right now. Maybe they think it's politically sensitive. Maybe they're worried about public reaction or media criticism. So they're just waiting, hoping the issue becomes less controversial over time. I don't know which theory is correct, but here's what I do know. Every day these cases sit in limbo is another day that gun owners across America have their rights restricted. Every day of delay is another day that unconstitutional laws remain in effect. And starting January 1st, 2026, just days from now, all those restrictions become even more entrenched. States will have had more time to enforce them. More gun owners will have been arrested. More precedents will have been set. Time is not on our side here. Okay, so we've covered all the bad news from Bloody November. Now let's talk about the good news. Because yes, there is good news. The Supreme Court accepted 2 gun cases, and these cases could potentially change everything in 2026 and beyond. Case 1, Wolford versus Lopez, the Hawaii carry restrictions. This case challenges Hawaii's post-Bruen carry restrictions. And folks, Hawaii went crazy after the Bruen decision. Remember, the Supreme Court ruled in Bruen back in 2022 that states can't require people to show a special need or good cause to carry a firearm. Constitutional carry must be allowed. Hawaii's response: okay, fine, you can carry, but you can't carry anywhere. They created sensitive place restrictions so broad and so comprehensive that you'd be hard-pressed to find a single location where carrying is actually legal. Schools? Banned. Government buildings? Banned. Parks? Banned. Beaches? Banned. Parking lots? Banned. Private businesses? Banned by default, unless they put up a sign explicitly saying guns are welcome. That last one is what Second Amendment advocates are calling the vampire rule. You know how vampires can't enter your home unless you invite them in? Same concept here. You can't carry in a private business unless that business puts up a firearms welcome sign. Think about how insane that is. Your constitutional right now depends on whether a business owner grants you permission. Imagine if your right to free speech only existed in stores that put up free speech welcome here signs. That's what Hawaii is doing to the Second Amendment. Now, here's why Woolford versus Lopez is so important. It's not just about Hawaii. After Bruen came down in 2022, multiple blue states did the exact same thing Hawaii did. New York, New Jersey, California, Maryland. They all said, you can carry, but we're going to ban so many places that your carry permit is basically useless. They're calling it compliance with Bruen. I'm calling it nullification. These states are trying to nullify the Supreme Court's decision by making it functionally impossible to actually exercise your carry rights. And the Supreme Court is finally going to address this in 2026. The core legal question is simple but huge. How far can states go in declaring locations off limits to firearms while claiming they're complying with Bruen? The court's answer will be absolutely critical. If they rule correctly and strike down these sweeping sensitive place bans that will restore carry rights to millions of gun owners in blue states, your carry permit will actually mean something again. But if they rule incorrectly, if they give states broad authority to declare anywhere and everywhere a sensitive place, then Bruen becomes meaningless. The Second Amendment becomes a right that exists on paper, but not in reality. We should get a ruling on this sometime in mid-2026, and it will either be a massive victory or a devastating defeat. There's not much middle ground here. Case 2, United States versus Hamani, the marijuana users case. This case deals with Section 922G3, the federal law that prohibits unlawful drug users from possessing firearms. Specifically, this case involves marijuana users, including people who are using cannabis legally under their state's law. Here's the weird legal situation. Marijuana is illegal under federal law, but it's legal for medical or recreational use in dozens of states. So you could be following your state's law perfectly, using marijuana with a prescription or in a state where it's recreationally legal, and you're still prohibited from owning guns under federal law. The constitutional questions in Hamani are huge. Question 1. Does a categorical ban on gun possession by habitual drug users survive the Supreme Court's scrutiny under Bruen's historical tradition test? Question 2. What counts as a habitual user? If you use marijuana occasionally, does that make you a habitual user? If you get one possession ticket, is that enough for the government to strip your gun rights? This case affects millions of Americans. We're talking about people across dozens of states where marijuana is legal who currently have to choose. Either give up your state legal cannabis use, or give up your Second Amendment rights. Here's my prediction on how this will go in 2026. I think the court will uphold some restrictions, but narrow the definition of habitual user. They'll probably say something like, yes, actual drug addicts with serious substance abuse problems can be prohibited from firearms. But casual or medical marijuana users can't be categorically banned just because marijuana is federally illegal. That would be a huge win for millions of gun owners. But we'll have to wait and see. Oral arguments will probably happen in spring 2026, with a decision by summer. Alright, now we get to the question everyone wants answered. Why did Bloody November happen? Why did the court reject 70 cases, but accept only 2? What's the real reason the Supreme Court is being so selective with gun rights? I've been studying the Supreme Court for years, and here's what I think is really going on. Reason 1. Chief Justice John Roberts is playing it safe. Roberts cares deeply about the Supreme Court's institutional reputation. He doesn't want the court to be seen as too radical, too partisan, or too political. So when it comes to controversial issues like guns, he's extremely cautious. He'll support gun rights when the case is clear-cut and the law is obviously unconstitutional. But he doesn't want to go too far, too fast. He's worried about public backlash, media criticism, and accusations that the court is just a rubber stamp for conservative policies. And here's the thing, Roberts is often the swing vote. You've got 3 solid conservative votes for gun rights: Thomas, Alito, Gorsuch. You've got 3 solid liberal votes against gun rights: Sotomayor, Kagan, Jackson. That leaves Roberts, Kavanaugh, and Barrett in the middle. If Roberts isn't on board, you don't get 5 votes. You don't hear the case. And that might be exactly what happened in Bloody November. Reason 2, they're being strategically selective. The Supreme Court doesn't just take cases randomly. They're looking for the right case, one with clean facts, clear legal issues, and a record that lets them make a broad ruling. Some of these 70 rejected cases probably had procedural problems, weird facts, or legal complications that made them bad vehicles for a major Second Amendment ruling. So the court passed on them, waiting for better cases to come along. Is that frustrating? Absolutely. Is it cowardly? Maybe. But it's also how the Supreme Court has always operated. Reason 3, political timing and optics. Let's be honest, we live in the real world, and politics matter. The court doesn't want to be seen as pushing a partisan agenda, especially on guns. So they're picking their battles carefully. They will expand gun rights. We've seen that with Bruen, and we're seeing it with the 2 cases they accepted. But they're doing it slowly, case by case, so it doesn't look like they're on some kind of ideological crusade. Reason 4, and this is the uncomfortable truth, we might not have 6 solid votes for gun rights on the Supreme Court. Thomas, Alito, and Gorsuch are clearly pro-Second Amendment. But Kavanaugh and Barrett, they've been inconsistent. And Roberts? He's playing defense for the court's reputation. So the reality might be this: we have 3 solid votes and 3 question marks. And that's why we're seeing this selective, cautious approach to gun rights. Going into 2026, that's something every gun owner needs to understand. So let's bring this home. What does Bloody November mean for you as a gun owner going into 2026? First, know your local laws right now. Starting January 1st, all those lower court rulings that the Supreme Court refused to overturn go into full effect. If you live in a state with magazine bans, assault weapon bans, or sweeping sensitive place restrictions, those laws are now locked in, at least until the Supreme Court changes course. You need to know exactly what's legal and what's not in your state. Ignorance is not a defense. I didn't know won't keep you out of jail. Second, watch those 2 cases closely. Wolford, Hawaii carry, and Hamani, marijuana users, will be decided in 2026. Those rulings will directly impact millions of gun owners. If you live in a state with sensitive place bans, Wolford could restore your carry rights. If you're a marijuana user wondering if you can own guns, Hamani will answer that question. Pay attention. These cases matter. Third, those 56 pending cases could still be granted. Just because they're in limbo doesn't mean they're dead. The court could grant some of them in early 2026. That would mean more Second Amendment cases, more opportunities for gun rights expansion. Don't give up hope on those. Fourth, get involved locally. The Supreme Court moves slowly, but your state legislature, your local sheriff, your city council, they move faster. Support pro-Second Amendment candidates. Join gun rights organizations. Make your voice heard. Votes matter. Activism matters. Fifth, this is a marathon, not a sprint. Bruen won a huge win in 2022, but cultural and legal change takes time. The effects of Bruen are still rippling through the courts. We're making progress. We're winning more than we're losing, but the fight is far from over. Bloody November was a setback, but it wasn't the end. We've got 2 major cases in 2026 that could change everything. We've got 56 more cases waiting in the wings, and we've got millions of gun owners who aren't giving up. Starting January 1st, 2026, some of you will be living under tighter restrictions, but others will be watching as the Supreme Court potentially expands your rights in those 2 cases they accepted. The question is, will the court ultimately do the right thing and protect the Second Amendment? Or will they continue this cautious, selective approach that leaves gun owners in limbo? We're about to find out. Look, Bloody November 2025 was a gut punch. 70 cases rejected. Millions of gun owners left without clarity going into 2026. But here's what I know for certain. The Constitution is on our side. History is on our side. And millions of Americans like you are paying attention and fighting back. The Supreme Court rejected 70 cases, but they accepted 2 that could be game changers. And those 56 still pending? They're not dead yet. This war is far from over. If this video showed you what's really happening with your gun rights, do me a favor, smash that like button, share this with every gun owner you know, and subscribe so you don't miss my coverage when those 2 big cases get decided in 2026. The Supreme Court is making decisions right now that will affect your rights for decades. Stay informed, stay armed, stay free. I'll see you in the next one.